G'day everyone, and welcome to week 7, which officially begins the second half of our legal ethics course. As you already know, at this point in the course we're discussing the obligations that a solicitor has to their client. We've talked about the obligation to give competent advice, we've talked about the obligation to follow instructions, and last week we spoke about the obligation to maintain the confidentiality of things that we learn from a client in the course of providing them with legal advice. This week, we're going to discuss the concept of a conflict of interest. This is a key characteristic of the relationship between solicitor and client. Because this is an advanced subject, many of you will already have completed your undergraduate courses on equity and on trusts. So many of you will already be familiar with the concept of a fiduciary duty. For those of you who haven't studied those subjects yet, two people or two entities are in a fiduciary relationship when the relationship is such that one party bears a powerful duty to look after the interests of the other party, even to the point of sacrificing their own interests for the sake of the other party. The law recognises a number of types of relationships where there are automatically considered to be fiduciary duties. One of those is the relationship between solicitor and client. This means that you must ensure that you never allow yourself or your firm to be placed in a situation where it could be suggested that you had divided loyalties. Your duty to the court is first, but beneath that, your duty to the client, your duty of loyalty to the client must be absolutely clear. There are a range of common circumstances which, in the past, lawyers have found are a conflict of interest. In this first video, we're going to look at conflicts between the interests of the client and the interests of the solicitor themselves. In the second video, we'll look at conflicts which may emerge if a lawyer is trying to represent two parties at once. In the third video this week, we'll look at conflicts of interest which arise when a lawyer is acting against a former client. And in the final video, we'll look at the specific issue of acting on behalf of family and friends. As always, we begin with the Solicitor's Conduct Rules. Solicitor's Conduct Rule 12.1 says a solicitor must not act for a client where there is a conflict between the duty to serve the best interests of the client and the interests of the solicitor or an associate of the solicitor. Rule 12.2 then says a solicitor must not exercise any undue influence intended to dispose the client to benefit the solicitor in excess of the solicitor's fair remuneration for legal services provided to the client. There are a few ways in which this might come up. For instance, imagine that you held shares in a company and your client was proposing to sue that company. Or imagine that the client sought your advice on a new commercial development which would likely reduce home values in a suburb where you own a house. In any situation of that type, it's going to be impossible to genuinely separate out the client's interests from your own interests. The only honest and reasonable thing to do is decline to act. In the key case for this area of law, a 1976 New South Wales case called the Law Society of New South Wales against Harvey, Mr. Harvey was involved in what amounted to 3 real estate joint ventures. One of the joint venturers, Glanville, was a client of Mr. Harvey's firm, and so the advice which Harvey gave to Glanville could not simply be for Glanville's benefit. Every piece of advice that he gave could potentially have had implications for him personally. He was hopelessly conflicted. Even if he still did his very best to give his best advice, it remained the case that every piece of advice he gave would have implications for him personally. One of the key ways in which a solicitor-client conflict may emerge is in any situation where the solicitor is either borrowing money from a client or lending money to a client. If a solicitor is lending money to a client, the solicitor is under an obligation to clearly disclose that this will involve a conflict of interest. They're under an obligation to take positive steps to encourage and facilitate the client obtaining independent advice regarding the loan and its terms. and they're required to take positive steps to encourage the client to look for alternative sources of funding. Frankly, while solicitors were once common lenders of money, I can't imagine too many firms that see contemporary value in dealing with the ethical minefield that would be necessary in order to lend money to clients. When it comes to borrowing money from clients, there are specific rules. Solicitors Conduct Rule 12.3 says that you may not borrow money from a client. You can't even borrow money from a former client unless the former client is a bank or similar institution, or alternatively, unless you can show that you have fully disclosed the conflict and taken steps to ensure that the interests of the former client are protected. Usually this means ensuring that they now have separate representation. Now, none of this obviously affects normal solicitor-client relationships or normal retail relationships. If you have a perfectly normal retail home loan on normal commercial terms and the bank becomes a client of your firm, that's no problem. Similarly, it's not a conflict of interest for a solicitor to seek to be paid their fees. You have to prefer the interests of your client, but not to the extent of acting like a charity. You will probably have already noticed that the key corrective measure whenever a conflict seems to be emerging is full and frank disclosure. Most of the time, the proper response to a conflict of interest is simply to cease to act. However, if the circumstances justify it, it is possible to continue acting, provided the client is fully informed of the conflict and has a free opportunity to take advice and to decide whether or not they consent to the conflict. You can see that what the rule is really saying is that a practitioner must at all times act with the most scrupulous honesty in any situation where a conflict might arise. The classic statement of this rule was also made in the case I referred to earlier, the New South Wales Law Society and Harvey. The Chief Justice, Sir Lawrence Street, said that the solicitor must make a conscientious disclosure of everything known to him that might influence the conduct of the client or anybody from whom he might seek advice. To disclose less than all that is material may positively mislead. Thus, for a solicitor to merely disclose that he has an interest without identifying the interest may serve only to mislead the client into an enhanced confidence that the solicitor will be in a position to better protect the client's interests. Frankly, rather like bias in the rules of natural justice, it's not enough to avoid an actual conflict of interest. If there is even the perception of a conflict of interest, that is, if a fair-minded bystander might reasonably form the view that the lawyer was conflicted in their ability to place their client's interests above everything except their duties to the court, then there is a conflict, no matter how diligent or fair or decent might be the conduct of the lawyer. Avoid these conflicts if you can. Put your client in a fully informed position if you can't avoid the conflict. No matter how much you might regret losing a client, it's still way better than losing your practicing certificate. So we have 3 more videos this week. In the second video, we build on the material in this first video by considering the ethical rules that apply if you're representing more than one client concurrently. Hopefully, you can already see some of the ethical problems likely to emerge in that situation. See you in the second video.